ahead and start that right now. Can I have a roll call, please?
Alderman Hayes. Alderman Kirkwood. Alderman Moiseo. Alderman Seeger.
Present.
Mayor Taylor.
Present. So the next order of business will be consideration of an appeal from the City Development Review Board.
Mayor, would you like to ask for a motion to move that forward in the agenda?
Sure. I'm sorry. Can I have a motion? Can I have a first? Alderman Kirkwood, second. Alderman Seeger, thank you.
And that can be by voice vote.
All those in favor? So on February 17th, 2022, the DRB held a hearing to consider objections to an establishment of a daycare center or a daycare home center at 3321 Burr Oak Road. Ms. Rosa Senroma submitted a business license application to operate a child daycare center in her residence at 3321 Burr Oak. She provided the information and has completed all the requirements for the licensure with the Department of Children and Family Services to operate a daycare center. Pursuant to Statute 14-1126 of the City's Code of Ordinances, notice of this application was provided to the neighboring property owners, some of whom submitted objections. The DRB heard testimony and evidence on these objections and determined that the applicant's proposed daycare center would not violate city ordinances or state statute, constitute a nuisance, or substantially change the character of the neighborhood. Can you hear this in the back? Okay, perfect, sorry. On March 7th, 2022, the DRB issued an order overruling the objections and allowing the applicant to move forward with her proposed child daycare home center. The city's Code of Ordinances allows persons who participated in the original hearing to appeal a decision of the DRB to the City Council, and this committee is tasked with hearing those appeals. So for those of you, I hope that explained what this committee is, because I don't know that I've ever seen one up here that we've had an appeal. So I want the audience to know exactly what is going on here. So Mr. Brad Einsberg, an objector who lives at 3320 Burr Oak Drive and testified at the hearing, has requested an appeal of the DRB's decision. Mr. Eisenberg or his representative, because he has an attorney, will be able to present the argument to our committee, but will not be considering they will not be considering new evidence tonight. This committee's sole purpose is to determine if the DRB incorrectly found that the applicant's proposed child daycare would have violated a city ordinance or statute, constitute a nuisance, or substantially change the character of the neighborhood. If the committee agrees with the DRB, then the objection will be overruled. If it disagrees with the DRB, the objection will be sustained. So here's how we're going to proceed. Mr. Eisenberg or his representative will be allowed to present an argument. Is he present this evening? Yes. Okay. The applicant, Ms. Senarone, or her representative will be allowed to present a response. Is she here this evening? The committee members will be allowed to ask questions to either party or to corporate counsel. We will vote on whether to sustain or overrule the DRB's decision. A majority vote of the committee members will be required to overturn the DRB's consideration. This committee's decision is final. Okay? Does everybody understand how this will proceed? Okay, so we'll start with Mr. Eisenberg. Would you like to come up to the microphone? That microphone right there. And if I pronounce anybody's name wrong, I'm truly sorry.
My name is, oh, my name, better, is Alan Lefkowitz, Lefkovitz, and I'm,
Yeah, you're going to have to get closer.
is this better?
Yes, much better.
Okay. Or if I just speak up, can I just turn this off?
No.
He has to hear you back there. It's got to be recorded.
Okay. So my name is Alan Lefkowitz, Lefkovitz, and I'm Brad Eisenberg's cousin, and I'm representing him in this appeal.
Yeah.
You still have to
Okay,
stay
here.
close to the microphone, sorry.
Hold that, yeah. Pull it as close to your mouth as you can. That's good. No, that was good.
Hello?
There you go.
Okay. Is this better in the back?
Yes.
Okay, good. So, my name is Alan Lefkowitz, and I'm Brad Eisenberg's cousin, and I'm representing him in this appeal. As the mayor said, this is an appeal from the order of the DRB overruling the objections that were filed in this application. So to begin with, there's a notice that is sent to people that live within 250 feet of the applicant's property. And I believe you have a copy of the that you have a copy of the notice regarding the operation of a child daycare home. So the notice says that if you have any objection to the pending child daycare home, you can indicate your objection below in a separate page or a separate writing. The notice does not limit the basis of appeals to those three grounds set forth in the ordinance. The notice is much broader. And what the notice says is that if you have any objection, you can bring that before the DRB. At the hearing, we were advised that the equity arguments would not be considered, even though that is part of the objection for the pending daycare home. So there's a miscongruence between the notice that is sent to the property owners and the ordinance. So for that reason, we believe that the DRB erred in not giving any consideration to any objection other than the three listed in the ordinance, and that the DRB should have considered and ruled upon the equity arguments brought. So here, I'm sorry, let's see. Okay. And then we were also advised that only the residents who filed objections can testify at the hearing. So in addition to the notice regarding the operation of a child daycare home, there was a notice of hearing that was sent out on, I think, January 20th of 2022. In the notice, it says that the objector, if you would have the option to appear before the review board and speak during the hearing. In fact, that really isn't true, because unless you appeared at the hearing, then the city would not allow a person who filed a written objection to then file an appeal. So apparently, the only people that can appeal the decision from the DRB are not people that filed objections, but people that filed objections and appeared at the hearing, which is contrary to the notice of hearing. So for that reason, we would ask that the DRB decision be reversed. There's nothing in this notice regarding the waiver of an appeal of an objector that doesn't appear at the hearing. And then after the hearing, there was no written decision that was sent to any of the 6 people who filed appeals. There was nothing to advise any of the objectors as to what their rights to appeal are and what the procedures to appeal are. And I believe, and we believe, that at a minimum, due process requires that a notice of the decision should be sent to each of the objectors and telling them and advising them of what their rights are. The same thing that the notice of hearing should have contained a provision saying that unless you appear at the hearing, then you waive your right to appeal. And the notice of hearing is silent to that. So in most of the cases that I was involved with, if there's a decision and then there's an appeal, then usually there's a written notice that's sent to the objector, which explains to them that this was the decision of the DRB and this is what your rights are. Well, that doesn't occur here. In fact, had I not met with the building commissioner, I never would have known what the appeal rights were. And when I did meet with the building commissioner, he said that we have the right to appeal to the city council, which really wasn't correct. So I was given wrong information. But had I not appeared at the city council meeting and counsel for the city of Waukegan explained to me what the appeal rights were, then we never would have appealed because we thought that we had to appeal before the city council, speak before the city council, and then ask that this matter be transferred to someplace else. So there's a lot of confusion as to what the rights of an objector are and how can you fulfill the right of appeal.
Is that your testimony now?
No. Well, that's my testimony so far.
Okay. We want to limit this because we do have a city council meeting at 7. So because we have other things on this committee, that's the crux of your case,
can't.
right?
No, I can't.
It's what?
No.
It's not? Okay.
You
go
can
ahead.
proceed.
Yeah, go ahead.
Okay. No, this is a very unique case. This is a case where my cousin violated a criminal statute a long time ago. He did whatever he had to do. He's a registered sex offender. He has complied with all the requirements. And now that this person from outside of his neighborhood is moving in and opening up a child daycare center, then there's a real risk that he may lose his house and that he may have to move. And that type of situation was not envisioned in the ordinance. So there's three statutory bases upon which to appeal, which we were not advised of beforehand and we were not made aware of beforehand. And we did not know until we actually went to the hearing. The first is the operation of a child daycare home would violate a city ordinance or a state statute, which we believe that it would. That the operation of this child daycare center would constitute a nuisance, which we believe that the evidence presented before the BRD shows that it is a nuisance. And furthermore, that the operation of the child daycare center would substantially change the character of the neighborhood. And we believe that it would. So even though we weren't prepared at the time of the hearing to make those arguments, and we did make them, we believe that the evidence before the DRB clearly shows that each of those three factors do apply here. So in order to determine the character of the neighborhood and whether it would be a nuisance or not, you have to understand what kind of neighborhood is this. And this is a neighborhood where there's limited egress and ingress. There's only 2 entrances to get into the neighborhood. There's 29 homes on Burr Oak Drive that are affected by the operation of a child daycare center. It's a very mature neighborhood. Most of the people that live in the immediate area of the child daycare center are elderly. Many of them are infirms. Many of them retired and have disabilities. So because of the nature of the neighborhood, there's very little activity that goes on between, let's say, 5 o'clock in the morning to 7 because people are still sleeping, and because it's a stable, mature neighborhood, there's very little traffic that goes on after 7 o'clock at night. The child daycare center has hours of operation from 5 o'clock in the morning until 11 o'clock at night, which goes completely against what the traffic is in this neighborhood. So for that reason alone, which is supported by the other objections, that the operation of a child daycare center in this neighborhood does 2 things. One, it creates a nuisance because you have excessive traffic coming in between 5 o'clock in the morning until 7, and then you also have excessive traffic coming in from 7 o'clock at night until 11 o'clock at night. So that constitutes both a nuisance as well as a change in the they're asking for a change in the character of the neighborhood. And then of the 15 homes that I think were served with notice, there were 6 written objections filed. And each of the 6 written objections ask that the license be not issued. And those 6 people are Brad Eisenberg, Regina Eisenberg, Linda Morgret, Linda Altman, John and Bonnie Marker, and Larry Bogan. So approximately 1/3 of the homeowners that received the notice filed appeals and objections saying that they believe that a daycare center is not appropriate for their neighborhood. So as you said before, the applicant operated a child daycare center or a daycare home at 2840 Westbrook Avenue, and then they later filed an application in order to transfer the license to 3221 Burr Oak. They purchased the property at 3221 Burr Oak Drive on September 24th of 2021. And again, during the day, there's 8 children. Hours of operation are between 5 to 6 and then 6 to 11. And then after, I think, 6 o'clock, they can take on an additional 4 children. Now, before she purchased the property, we believe that she had an affirmative obligation to check to see whether she can open a child daycare center at this location. And had she checked the lists a registered sex offender, she would have found and should have found that there's a registered sex offender right across the street from her. So part of her due diligence was to check to see whether she could open up a child daycare center at this location, and the answer should have been no. And the reason why not, because it violates the state statute that says that a registered sex offender cannot live within 500 feet of a child daycare center. So we believe that by granting the license then causes the violation of the state statute, and that is the first basis of objecting to the issuance of the license. And the state statute is 720 ILCS 511-9.3, which we hope is in the process of being changed. And then even at the hearing, the applicant testified that if the issuance of the license would cause my cousin to have to move, she doesn't want my cousin to move. That's not what she wants. So she in fact said that if the issuance of the license would cause him to move, that's not what she wants, and the license application should not have been granted. And there's House Bill 3913, which is in the Rules Committee, which is going to change all this, so that if there's a registered sex offender whose domicile was there before the license is issued, then there's no violation of state statute. Right now, as it's set up, is if my cousin had moved in sometime before 2008, then he would not be subject to it either. And that statute was changed in 2009. If they had updated that statute between 2009 and 2022, then we would not be here for the same reasons.
Can you repeat the House bill number that you just talked about?
Sure. It's here somewhere. House Bill 3913. So as it applies to registered sex offenders, what used to happen 10, 15, 20 years ago, that's in a state of change. And the way that the statute is set up right now is we're kind of in a catch-22. It's, yes, the legislature is aware of the fact that instances such as this create substantial problems, and they're trying to fix those problems. So we believe, first of all, that the issuance of the license does cause a violation of state statute. The next issue is whether the issuance of the license would create a nuisance or not. And both Mr. and Mrs. Eisenberg, as well as the other people that filed their objections, the strongest basis of the objections is because of the increased traffic, because of the increased noise when the children are outside, and because of the garbage issue, that there's so much garbage which is being generated and that the garbage is not being picked up. And because the garbage isn't being picked up, it attracts animals, skunks, and mice, chipmunks, foxes, and coyotes. And the people in the neighborhood consider that a nuisance. The drop-off times between 5 and 11 o'clock disrupt and change the character of the neighborhood because it's a bedroom neighborhood, which is basically retired people with disabilities, and their lifestyle is not conducive to having a child daycare center in their neighborhood. And the conclusion is that a child daycare home would disrupt the neighborhood and the daily lives of the long-term residents. As I said before, my cousin has been a resident of this neighborhood since 2010. His neighbors look at him very highly, and they want to do what's best for the neighborhood, and they believe what's best for the neighborhood is to leave the neighborhood in the status quo, not make any changes, and not introduce a new business in the neighborhood. There are no other businesses there. This is the only business being operated at any of the homes, with maybe the exception of one, and that disrupts the neighborhood. Larry and Darlene Bogan wrote an objection that the new owner has not taken any steps in order to integrate herself as part of the neighborhood. There were questions as to whether opening a child daycare center with an 18-hour day is a nuisance and a change in the character of the neighborhood. They believe that it is. They questioned the number of children, but again, we go back to this other question that there's excessive garbage and uncovered garbage containers, which then draws in animal skunks, foxes, and cats. So basically, her objection and his objection was they don't agree as to the number of children, they don't like the hours, and they certainly don't like the garbage and litter, and they don't like the fact that there's going to be cars going up and down their street from 5 o'clock in the morning until 7 o'clock in the morning, when most of the people are asleep and waking up, as well as pickups as late as 11 o'clock at night, because that disrupts this neighborhood. Then Linda Altman also filed an objection. One of her biggest complaints, or one of her biggest objections, was that there's non-resident traffic because it's a very old neighborhood and it's a very mature neighborhood. The residents are very concerned.
So this is not to review the evidence. This is just, and we understand what your objection is.
Right.
We do.
And this is to decide whether there's been either a violation of state statute, which we clearly show that there is, and also to show whether it's going to change, whether they're asking to change the neighborhood, and this is all part of the evidence, and or whether there's a nuisance. So if you look at the evidence presented at the hearing, both my cousin's evidence as well as the evidence presented by the other objectors, it clearly shows that the people that live in this neighborhood do not want a child daycare center in their neighborhood because, one, of the increased traffic of people coming up and down 2 streets, because there's only 2 ways of egress and ingress, the fact that they don't know who these people are, and the fact that there's going to be excessive noise. And I guess one of the biggest issues is the garbage problem, because the garbage is creating a nuisance where it attracts vermin and other animals. So each of the points argued in the various objections raised, which again were 6 objections out of maybe 15 homes, or a third, all of the objections clearly stated that the residents of this neighborhood believe that this kind of business does not conform to the neighborhood. It creates a nuisance. And as it applies to my cousin, it also creates a violation of state statute. So for each of these reasons, we would ask that this tribunal reverse the decision of the DRB and not grant the license or pull back the license. Oh, and there's one other point. I had asked for a transcript of the proceeding below, because if this is an appeal based on the evidence presented at the proceeding below, there's two different types of evidence. One is documentary evidence, such as the objections, but then there's also the evidence having to do with testimony. And without a transcript, you cannot tell what the other arguments and what the other evidence was. So unless everyone here is going to spend an hour and a half listening to a tape of what the proceedings were, then that evidence is not going to be considered by this committee. So there's many due process issues involved here, and I think that they have to be addressed.
Thank you, sir. Next will be the daycare center representatives. This is Ms. Rosa Senroman.
Good evening. My name is Laura Horner, and I am here on behalf of Rosa. And I'll try to keep, I know that there's a time frame, so I'll try to keep my comments brief and just respond to things that were brought up by council. First of all, it's obvious that in the city of Waukegan has all of its codes and procedures mainly online, most easily online. If there would have been anybody who just bothered to go to look at the Waukegan City Council and all of the codes of the city of Waukegan, they easily can find that there is an appeal process for the objections that were denied at the last hearing. So I just wanted to make it clear, it's obvious and it's accessible to the public. The first then argument after the process argument, which I don't really believe is relevant at this point, was does this violate a city ordinance or a statute? The main argument that council makes under this section is that it would be a violation of the codes of the state of Illinois because there was a sex offender living within a certain distance from the daycare facility. I just wanted to make it clear to the council members that state of Illinois law does not apply to the daycare provider. That's the responsibility of the person who has been convicted of a sex crime. It's a sex offender violation code, excuse me. And it's not, the onus is on the offender. It is not on any other person or any other business. So this does not, Rosa is not violating a state statute, nor has it been found that she's violated any city code or ordinance by opening a daycare facility at this address. A third, is this going to be, second, is this going to constitute a nuisance in the neighborhood? Council tries to make it look like this is going to be a daycare facility that operates for 18 hours a day and that there is going to be a tremendous amount of traffic going up and down Burr Oak and things like that. Burr Oak is a relatively busy through street through that neighborhood. There's school buses that run up and down that street. There's people driving up and down that street, taking their children to school. The fact that Rosa would have 5 families coming to drop off children. She has 8 children with 5 families. So only 5 additional people would be bringing their children in the morning to her residence, which is at between 5 and 7 a.m., and then picking up the children between at about 5 or 6 p.m. At this point, she has no people that are waiting to put their children into her daycare. That would be an extended hours type of situation. So it's a very normal, go to work 9 to 5, and then come back and pick up your children type of situation. It would not really increase dramatically the amount of traffic that is through that street. In regards to the noise that maybe 8 children will make, either in the morning, in the summertime, while they're out playing in the backyard, or after school, I think that's de minimis, given that any family could move in and also have children. So how can you constitute that be a nuisance for a daycare versus if a family moved in with a large, like 5 or 6 kids, they would make the same amount of noise and they wouldn't be restricted from living in this elderly subdivision. In regards to the garbage, that was also brought up, Rosa has operated a daycare facility for 11 years. She has never had a violation from either the City of Waukegan or the Department of Children and Family Services. She is used to complying with any type of regulations that are put upon her, and garbage has never been an issue. In addition, the objections to this, Rosa has not obviously opened her daycare facility at this residence at this time, so there is really no evidence about how she manages the garbage. But what I can tell you is past history is what predicts the future, and Rosa has never had a violation in regards to that. Finally, in regards to the status quo of the neighborhood, I think I touched on that a little bit in regards to the nuisance. However, it was admitted by council that there was at least one other home business that is run in this neighborhood, that this is a small business, that the essence of the neighborhood would substantially change is what he argues because of the character of the neighbor. Well, essence of neighborhoods always change. They're always growing. They're always in flux, and that's what we want. We want for, some people move out. We want people to move in. We want home buyers to move in rather than home renters. We want some rejuvenated young life in a neighborhood versus everybody, to be elderly and things of that nature. They're oftentimes, younger kids can often bring life to elderly people. So the fact that there might be some children in this neighborhood should not be a restriction to having a daycare facility in this particular neighborhood. It would not change the character of the neighborhood any more than the residents a few doors down that have some children of their own. So it's not really going to change that either. I don't think at this point that there has been proof that there was anything improper that happened when there was a denial of the objections. I don't believe now that there has been any proof to this body here that the objections being overruled at the last hearing was the incorrect decision, given the evidence that was presented at that hearing. So I ask that the decision, of the prior board stand.
Thank you both. Okay. Did any of the committee members want to ask any questions? I guess one thing I will say is House Bill 3913 never got out of committee, if I believe correctly. So that was last spring, so that does not apply for this. And I don't know that it will. I guess my comments on it is, this is just a very sad situation all the way around. You've got a daycare center that home businesses are allowed to, daycare centers can be allowed to open. That's not something that we can necessarily say you can't open a business, you can't do this. That, you know, as long as you're complying, there's not a lot we can say about that. On the other hand, you have a gentleman here who has worked very hard and put money into his home that is now at risk of losing that. The part that doesn't help us here is there's no legislation that protects you. And as you said, in 2008, is if you'd have been in that home 2 more years, you'd have been protected. But anybody up here on this committee doesn't have that to fall on. So the question comes down to, does anybody here have questions? Yes, Alderman
Question.
Hayes.
Before we get into substance, if I could just ask a question about the procedure. So as the appellate review board, so to speak, we're only able to consider the 3 elements that were considered by the DRB, is that correct? And whether their analysis as to any of those 3 elements was wrong?
Yes.
So any decision we make is confined to?
Yes, the decision on whether to sustain or overrule an objection is vested in the DRB. The DRB can only sustain an objection if it finds that the proposed child daycare center would violate a city ordinance or state statute, would constitute a nuisance, or would substantially change the character of the neighborhood. The DRB, at its hearing, where heard testimony, found by a vote of 6-1 that none of those applied. Based on the record that was presented, both the minutes, the objections to hearing packets, your determination tonight will be if the DRB correctly applied those standards.
Okay. Now could I ask a question? Okay. I believe the application for the child daycare center said that there would be 8 children. Is that correct? Okay. And then, so it's 8 and then 4 of her own. You have 4 kids. I saw 8 plus 4, so I'm just trying to understand what the...
8 total children she's licensed for.
Okay, so there's going to be 8, yeah, sure, come on up.
5 families, I believe.
5 families, 8 total children they're licensed.
8 total children, right. And the 8 total children is all that she's licensed for by the Department of Children and Family Services.
Okay, so at the moment, it's only 5 families.
5 families, because there's siblings that come.
Sure, of course,
Yeah.
but that could change.
Yeah, that could possibly change.
And how many homes are in the neighborhood? I heard 29. If I got that correctly, is that in the that's on the loop? There's only one point of ingress and egress that I saw on the map. So the main loop just has 29 homes. Is that your understanding?
There's more houses in the neighborhood.
There's more than that. Okay.
I can count them real quick.
It looked like it was more than 29. We don't need a definite answer. My question gears more toward nuisance, and if you had a number of homeowners object based on the increased traffic in the neighborhood. I don't live in that neighborhood, but I put a lot of stock in what somebody else might say. So if they've complained that the additional traffic would create a nuisance, you know, what's your position as to why there would not be a nuisance as a result of the additional traffic, which could be up to 8 cars if it's 8 different families multiple times a day?
Right. It could be up to 8 cars multiple times a day, but during those times a day, you have to remember there's also people going to and from work. As I said earlier, there's buses driving up and down that same loop. So this is traffic that's already there. It's not necessarily a street that there's barely, you know, like a cul-de-sac where there's not very much traffic going in and out. That's not what this street is. This is a through street for many types of vehicles, including school buses,
Sure.
on the same days that this daycare would be in operation.
So you don't think it's a nuisance?
I think it's de minimis.
Okay. And you said the neighborhoods are always in flux. I would agree with you. You said, you know, you want people to move in and you want people to move out and you want neighborhoods to change. Is it your position that you want to force people to move out?
No, absolutely not. I don't think anybody wants to force anybody to move out,
Yeah.
but that includes Rosa, who has also purchased a home in that neighborhood. It's not her responsibility to check to make sure there's no sex offenders within a certain, you know, according to Waukegan, 250 feet of her home. That's not her state and or legal obligation. It's the, you know, Rosa didn't violate a significant statute of the state of Illinois years ago to be put on the sex offender registry.
Sure.
You know, the appellant did. And it's therefore the state laws apply to the appellant. And I understand the plight of someone in that situation, but I can't. But the laws do not obligate other people to defer to those individuals who might have a restriction on their residency. The law does not obligate them to do that.
You're saying she doesn't have an obligation to check?
She absolutely does not have an obligation. And when she bought this home, she did not know she was not obligated to check who lived within a certain radius. She was not legally obligated to do that. There's no DCFS rule that she's obligated to do that. No state of Illinois statutes she's obligated to do that, and no city of Waukegan ordinance that she's obligated to do that.
Sure. I think, you know, my question before is a little bit unfair. Of course, nobody ever wants to force anybody to move out, but wouldn't you agree that forcing somebody to move out against their will, so to speak, would change the character of a neighborhood?
I don't think it would change the neighborhood in a necessarily a bad way. There's always people who have to move out. People die. People, live somewhere for 20 years and then they have to move for financial circumstances, or they're downsizing, or any number of reasons people are moving in and out. The fact that the state of Illinois has put this restriction on certain people, that's the state of Illinois, and that's what the state of Illinois has decided what's fair under certain circumstances. And they have decided that these individuals have an obligation not to live within a certain feet of schools or daycare facilities or a number of different places. And the state of Illinois has put that obligation on them and not vice versa. And, that's what legally the state views as being fair at this point in time. Until, Springfield changes that in any way, that's what the people of the Illinois and the laws say is fair.
Okay. Thank you for answering my questions.
Yes, you're welcome.
Any other questions?
I know I'm not on this committee, but can I just clarify one thing he said? You asked about the whole neighborhood. Letters only went to people within 250 feet of the daycare, is that correct? So it didn't go to the whole neighborhood. So not everybody got to comment.
Not everybody got
I got
noticed.
calls from people who were outside of the 250 but they weren't legally allowed to comment because they didn't receive a letter.
Okay, that's really helpful. Thank you.
Thank you, Mayor.
Any other questions? So, at this time, we're voting. Do you want to clarify?
Yeah. So the parties have been given an opportunity to speak. The committee has been given the standards that they are asked to review on this. And as we are taking an appeal of an objection, it can be kind of difficult to follow what we're doing. So I'm going to try and make this as simple as possible for the committee. That if you, I think it would be appropriate to take a motion to sustain the objection. If you vote to sustain the objection, if you vote aye on that, that means that the objection is sustained and that the license for the home daycare center would be denied. If you vote no on sustaining the objection, that means the objection will be overruled and that the license will be issued. Once again, we are asking the question of whether we are going to sustain an objection based on the DRB's decision. And the DRB had very specific standards. Does anyone on the committee have a question as to what the standards are again?
Corporation Counsel, can you repeat those three so that everyone is aware of that?
Absolutely. So the DRB was asked to determine whether the proposed daycare center would violate a city ordinance or state statute, would constitute a nuisance, or would substantially change the character of the neighborhood. The DRB found that none of those factors had been met, and therefore overruled the objection. So sustaining the objection means the license is granted, or the license is denied. Overruling the objection means that the license can go forward. Is there a vote to sustain the objection?
Could I make a comment before we actually vote?
Yes.
It's not a question for the applicants. Just everybody that's on the panel, if we're considering three elements, my position on these three elements, to the extent that I'm allowed to tell you what it is that we've heard that 5 separate homeowners from within 250 feet, if people within 250 feet of the proposed daycare receive notice of this and had an opportunity to object, that's 5 separate houses within 250 feet that are objecting to the licensing of the daycare. So without being able to completely conceptualize 250 feet, that is most of the people within that radius are objecting to the daycare based on the traffic. Cars pulling up in front of their house, cars reversing in and out of their driveway. They don't like it. We don't live in their neighborhood, but we should put a lot of stock in what it is they say. And as for element C, the third element, whether the character of a neighborhood would change, I believe that if somebody is forced to sell their home, background aside and all the other baggage that comes with this, I think objectively speaking, if somebody is forced to sell their home against their will, that changes the character of a neighborhood. Certainly changes the character of a block, certainly changes the character of the homeowners within 250 feet, which is the only notice that was sent out. So I think if you're looking at the three elements and you're considering whether, with all deference to the DRB board, I don't think that we can find that a city ordinance was violated, but I think if you're looking at the increase in traffic volumes in the immediate area of the daycare and whether the character of the neighborhood would be changed, you're obligated to consider those facts, not new evidence, but those facts that were brought before us today. So I'm gonna vote to sustain the objection when that time comes, but I want you to understand the basis for my doing so.
Can I have clarification on, was it 5 homeowners, like separate households, or was it 5 people?
I have 3320 Burr Oak, which is one of the objectors. We have 4750 Crest Court, 4759 Crest Court, 4755 Crest Court, and 3259 Burr Oak. Which would be 5 separate houses
5
as far as I
separate
can.
addresses, okay.
Okay. So at this time, Mayor, if you could ask for a motion to sustain the objection.
But I will have you clarify one more time. Sustain means,
Sustain means if you vote yes to sustain, that means that the daycare license is denied. If you vote no, it means the objection is overruled and the daycare goes forward. Does everybody get that?
Counsel, are we looking at what the DVR has stated and not so much regarding the homeowners in that particular area? Because they have found that there has not been any violations in those 3.
You are looking at did the Development Review Board correctly apply the standards based on the facts that were presented to them.
Okay. Alderman Hayes, you wanted to make a motion to sustain the objection. Was that correct? Okay. Is there a second to that? Okay.
I have a question. So abstaining, once again, means yes, we're allowing it. Is that correct?
Sustaining, and it means,
Yes, but only the members of the committee are voting on this.
Yeah.
So
The members.
there was a motion to sustain. If there is no second, the motion fails. Is there a motion to, well, with that, is there a motion to overrule the objection? Anyone can make that. Mayor, you can make that if you.
Okay, I'll make a motion to overrule the objection.
There's a second from Alderman Kirkwood.
Okay, so then there's a vote, right?
Yep.
Okay.
So this is a vote to overrule the objection. Now, we've just reversed what I just said previously. So a vote yes means that the objection will be denied and the daycare can go forward. Alderman Hayes.
no.
Alderman Kirkwood. If you want to overrule the objection and let the daycare go forward, you vote yes. If you want the license to be denied, you vote no. Yes. Okay. Alderman Seeger.
Yes.
Mayor Taylor.
Yes.
Okay. So the objection is overruled. The decision of the committee is such that the objection to the license has been overruled and the license may be issued.
Thank you, everyone. We will continue with the rest of the committee. Again, I'm going to say this is a tragic situation. There's no winners here. There just isn't winners here. And yeah. Where'd Alderman Hayes go? Okay. Alderman Hayes, would you like to hold the rest of the items over since we're so far over tonight? Okay. I have a motion to hold the rest of the items on the appeal and code revisions, appeals, and negotiations over. Can I have a second? Alderman
Second.
Kirkwood? All those in favor?
Aye.
Thank you. Being no public comment, can I have a motion to adjourn? Alderman Kirkwood, second. Alderman Hayes, all those in favor? Aye. Let's take a 5-minute break, and then we will be back here for council. Thank you, everyone.